The moment an officer leans into your window at a DUI checkpoint with that first question, most drivers fall into a trap. You answer honestly, and within 30 seconds, you've given them everything they need to escalate this into a full investigation. Through analysis of over 200 checkpoint encounters on body cam, I've identified the exact pattern. 3 specific questions designed to build probable cause. Answer wrong, and you've extended a 20-second stop into a 30-minute interrogation. I'm showing you the 3 questions cops ask at every checkpoint and the exact responses that shut them down. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Question number 1 is, have you been drinking tonight? Officers' opening move at 90% of checkpoints. The second your window comes down, they hit you with this. Here's the real situation. They're asking because your answer either builds their case or it doesn't. Officers are trained. This creates what they call a verbal admission. Say yes, even 1 beer 3 hours ago. That statement goes directly into their report as evidence. Say no, and they later claim they smelled alcohol. Now you've lied, which makes you look guilty. Either way, you lost tactical position. Why does this work on you? Cooperation feels right. You think honesty gets you waved through faster. You think refusing makes you suspicious. So, you answer. The moment you do, the officer has your voice on body cam, listening for slurred speech, watching for bloodshot eyes, evaluating cognitive function by response speed. Your answer isn't just words, it's evidence being collected. Body cam footage shows drivers who answer are 4 times more likely sent to secondary screening than drivers who don't answer at all. The question itself is a filter. Answer it, and you give them data points to justify extended detention. Officer training manuals teach initial contact is called the preliminary screen. Officer has 15 to 20 seconds to decide if you get waved through or pulled aside. That drinking question is their first test. They're not just listening to what you say. They're observing how you say it. Delayed response means possible impairment. Overly detailed answer means possible deception. Nervous tone means elevated suspicion. Question is a tactical probe designed to generate observable behaviors justifying further investigation. Your counter move. When officer asks if you've been drinking, I'm not answering questions. I'd like to be on my way. Deliver it calm, polite, firm, no explanation, no justification, no apology. This invokes Fifth Amendment protection while making clear you're not playing interrogation game. You're not being difficult. You're being tactical. Strategic advantage. Without a verbal response, officer can't claim you admitted drinking, can't claim you lied, can't analyze speech patterns or cognitive delay. You've eliminated their primary evidence gathering tool in the first 10 seconds. On video, you look composed, sound respectful, asserted constitutional right. That's tactical control. Lock this in right now. I'm not answering questions. I'd like to be on my way. Say it 3 times out loud. That response is your defensive line at every checkpoint. You've shut down their first evidence question. Body cam analysis reveals what happens next. When officers can't get you to admit drinking, they immediately shift tactics trying to build probable cause through circumstantial details. Question number 2 is their go-to move. Sounds innocent. Feels conversational. It's a trap that works on almost everyone. Question number 2 is where are you coming from or where are you headed? This question deploys after you refuse the drinking question, or sometimes it comes first as a rapport building opener. Either way, same trap. Here's the real situation. Officers ask this to establish timeline and location data that supports an impairment narrative. If you say you're coming from a bar, restaurant, friend's house, sports game, they now have a location associated with potential alcohol consumption. If you say you're headed home from work at 11 p.m. on a Friday, they've got a time frame that fits drunk driving patterns. Your innocent answer just became part of their probable cause calculation. Why does it work on you? Because the question feels harmless. It's small talk, the kind of thing anyone might ask in casual conversation. So you answer without thinking about how that information will be used. You tell them you were at a birthday party. You mention a concert. You say dinner. And every single answer feeds directly into their suspicion matrix. Where you were plus when you were there equals opportunity to consume alcohol. That's exactly how they think. Field reality? In documented checkpoint encounters, officers use location responses to justify extended detention. Pattern goes like this. You say restaurant. Officer asks which one. You answer. They ask what you had to eat. Now you're in a full conversation, and they're gathering more observational data with every exchange. Meanwhile, the 20-second checkpoint stop just became a 2-minute interrogation. All because you answered where you were coming from. Video evidence from checkpoint body cams shows officers writing down your location answer in their notes. Those notes later become part of the arrest report if they decide to detain you. Your casual response is documentation they'll use against you in court. Officer training materials specifically say location questions serve dual purposes. First, they extend the interaction, which gives the officer more time to observe you. Second, they create investigative leads. If you mention a location, the officer can follow up with questions about that location. This technique is called controlled conversation. The officer guides the dialogue in ways that seem natural but are actually tactical. Each answer you give opens the door to another question. And every question is another chance for you to display signs they can characterize as impairment. Countermove is identical to question 1. When they ask where you're coming from or where you're headed, respond, "I'm not answering questions. I'd like to be on my way." Same tone, same delivery. Calm, respectful, firm. Don't explain why you're not answering. Don't apologize for declining. Don't offer partial information thinking it'll satisfy them. Just repeat the countermove and maintain tactical position. Strategic advantage? By refusing to provide location information, you deny them the ability to build a circumstantial narrative. They can't connect you to a location. They can't establish a timeline. They can't use your own words to suggest you had opportunity to drink. Without that information, their ability to justify further detention weakens significantly. And again, on camera, you're exercising a constitutional right in a calm and composed manner. That's how you win the tactical exchange. Drill this response again. "I'm not answering questions. I'd like to be on my way." Repeat until it's automatic. That phrase is your shield against investigative fishing. You've refused twice. Some officers wave you through, others escalate. Question number 3 is their escalation, where they try to gain physical control. Question number 3 is, do you mind stepping out of the vehicle? Sounds like a question, but it's not. Under Pennsylvania versus Mims, officers can order you out during any lawful stop for safety. Establish law. But they almost never phrase it as an order. They phrase it as a request. Do you mind stepping out? Can you step out for me? Asking for voluntary compliance, because if you voluntarily exit, anything they observe outside becomes evidence. Balance, coordination, how you walk, how you stand, all becomes impairment assessment when you step out voluntarily. Why does this work? Sounds polite, sounds optional. Most think refusing makes things worse, so they comply. Feet hit pavement, an officer evaluates gait, watches for stumbles, observes balance, notes if you use car door for support. You gave them 5 evidence categories by exiting when you could have forced a lawful order first. Body cam shows 90% of drivers who exit voluntarily get asked to perform field sobriety tests. Once you're out, officer already observed walking and standing. They've seen enough to justify testing. But stay in vehicle and force them to order you out. That changes dynamics. Now they articulate a reason on camera. More than "I wanted to talk outside." They need reasonable suspicion. Officer training says getting driver out creates advantages, removes vehicle interior protection, allows full body observation, puts driver where they demonstrate physical abilities. Walking to testing area, standing while speaking, maintaining balance on uneven pavement, all pretest observations building impairment case. Countermove is different because of Mims. Officer, are you ordering me to exit the vehicle, or are you requesting? This forces clarification. If request, I decline. I'd like to remain in my vehicle. If order, I'm complying under your order. Before I exit, what is the lawful basis for this order? Then comply, but created video record exit was not voluntary. Complying with command, not volunteering cooperation. Strategic advantage. Clarifying request versus order eliminates voluntary compliance. If request and you decline, they let it go or escalate to order. If escalate, you made them articulate justification on camera before complying. Justification can be challenged later if insufficient. Either way, not giving voluntary evidence, forcing them to assert lawful authority or back down. Memorize this. Officer, are you ordering me to exit the vehicle or are you requesting? Practice responses. I decline. I'd like to remain in my vehicle. Or, I'm complying under your order. What is the lawful basis? These protect you. If you exit, next move is requesting field sobriety tests. Walk and turn. One leg stand. Horizontal gaze, nystagmus. Critical intel. Field sobriety tests are voluntary in almost every state. You're not legally required, but officers never tell you that. They phrase it like you must comply. Step out and walk this line. I need you to perform tests. Every statement sounds mandatory when you have legal right to refuse. Why are FSTs a trap? Subjective. Even sober people fail. Age, weight, physical condition, footwear, road surface, weather, anxiety, all affect performance. Officers watch for specific clues. On walk and turn, 8 clues. Display 2, and they mark you impaired. Some clues, starting before instructions or using arms for balance, happen to anyone under stress. Tests aren't designed to prove sobriety, they generate impairment evidence. Once officer asks FSTs, they've already decided you're getting arrested. Tests just confirm. Body cam shows and checkpoint stops, officers who request tests almost never let drivers go, even if they pass. Officer observations during tests become arrest justification whether you pass or fail. Can't win. Only give them more evidence. When officer requests field sobriety tests, I'm declining field sobriety tests. I'd like to speak with an attorney, calm and firm. Don't explain. Don't ask if required. Decline and invoke counsel. In most states, refusal cannot be used against you at trial, not evidence of guilt. Exercise of constitutional right. State law varies. Refusing FSTs does not prevent arrest. If officer has enough evidence, they still arrest. After arrest, different decision. Post-arrest chemical testing. Breath, blood, urine. Most states have implied consent laws penalizing refusal of chemical tests after arrest. Refusing post-arrest breath test can mean automatic license suspension 6 months to a year. That's separate from roadside FSTs. Roadside tests before arrest are voluntary, no penalty. Chemical tests after arrest trigger implied consent, and refusing has consequences. For checkpoints, refusing FSTs when sober protects from subjective results. Refusing when you've been drinking prevents giving additional evidence. Refusal is almost always the tactical move. Recording and physical protocol. Your recording plus their body cam equals tactical advantage. At every checkpoint, record on your phone. Before officer reaches window, start recording. Place it visible, dashboard mount, or hand on wheel. When officer approaches, officer, for everyone's safety and accuracy, I'm recording this interaction as well. Not confrontational. Protective. Why recording matters. Body cam footage can disappear. Technical malfunctions. Footage deleted. Requests denied. Your recording is your copy. Captures officers' exact words. Documents responses. Shows demeanor. Proves you are calm and compliant. When officers' report contradicts what happened, your video challenges their narrative. Defense attorneys use personal recordings to expose discrepancies. That footage has gotten charges reduced and dismissed thousands of times. If officer questions recording, just for transparency and accuracy, officer, don't argue. Don't explain legal right. State reason and move forward. Recording police during public encounters is legal in almost every state. Officers know this. If they interfere, that interference becomes evidence of improper conduct. Physical protocol. First 60 seconds sets tone. See checkpoint signal. Pull in calmly. Stop. Engine off. Keys on dashboard visible. If dark, dome light on. Hands 10 and 2 on wheel. Keep them there. Window crack 2 to 3 inches maximum. Lock doors. Why this matters. Visible keys show not trying to flee. Dome light reduces safety concerns. Hands on wheel show not reaching. Demonstrates compliance. Reduces tension. Partially cracked window allows communication while limiting officers' ability to claim they smelled alcohol. Odor of alcohol is common justification for extended detention. Cracked window makes claim harder. Locked doors prevent opening door without asking you to unlock. When officer reaches window, vehicle is secured. I'll pass my documents through the window. Take license, registration, insurance, hand through crack. Don't unlock door. Don't roll window down further unless ordered. Keeps barriers while showing cooperation. Complying with law, not surrendering position. If officer asks to roll window down, officer, are you ordering me to roll my window down or requesting? If request, I'd prefer to keep my window where it is for my safety. If order, what is the lawful basis for that order? Then comply under order, creating video record of justification. Applies to door locks, exiting vehicle, any action changing position. 4 counter moves for any police encounter. Am I free to leave? I'm invoking my right to remain silent. I want to speak with an attorney. I do not consent to searches. At checkpoints add, I'm not answering questions. I'd like to be on my way. These 5 cover every scenario. Right now, say each 3 times. Am I free to leave? I'm invoking my right to remain silent. I want to speak with an attorney. I do not consent to searches. I'm not answering questions. I'd like to be on my way. Your tactical shield. Stay calm, stay tactical, stay in control. Composure is advantage. Calmer you remain, fewer behavioral cues you give to justify detention. Slow breathing, steady voice, minimal movement. This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If you found this valuable, click like, subscribe, and hit bell for critical traffic stop intelligence. Share with anyone who drives. You've learned the 3 questions officers use at checkpoints and exact counter moves. But there's more training you need for every police encounter. The next video shows advanced counter tactics for different scenarios officers use to escalate stops. It's right here on screen. Click now to complete preparation. Don't wait until you're in the situation. Watch now while training is fresh. Control the interaction, control the outcome.